TC24, please inform all the participants that we are live streaming on YouTube as well this year.
Sure, sir.
Pranati, is the audio clear?
Yes, sir.
Yeah.
Hello, hello, hello. My audio is clear.
Yes, sir.
మీరు కూడా అన్మ్యూట్ చేయండి. Is the audio clear now?
Yeah. అవసరం లేదు సార్. ఏంటి ఇప్పుడు మాట్లాడద్దు.
Yes, ma'am. Hello.
మాట్లాడు.
అయితే దీంతో చేయాలి. కానీ ఎక్కువ అవుతుంది కదా. అది మ్యూట్ చేశారు అక్కడ. Pranati, the voice is echoing, right? Is it echoing?
Yes, sir. A bit echo, sir.
A bit echo. Is it echoing even now?
Yes, sir, a bit.
A bit? Okay. అయితే ఒకసారి దీన్ని లేకుండా ట్రై చేయండి సార్. కొంచెం ఎక్కువ అవుతుంది వాయిస్ ఎక్కువ అవుతుంది. How's the audio now? Is it still echoing? Can you tell me if it's echoing now?
Yes, sir. It's still echoing.
How is it now? It's better now, right?
Yes, sir.
I'll just read a sentence. Just tell me if it is echoing or not. Governments have initiated the demolition of homes in encroaching areas of water bodies. Is it still echoing?
Yes, sir.
Yes,
There is
sir.
still a bit of echo.
There is a bit of echo.
Yes, sir.
How's the audio now? Is it better?
Sir, it's echoing
No,
more.
sir.
Echoing. Mute channel.
It is even more echoing right now.
How's it now? Is it better? Echoing.
No, sir. Still echoing.
Still echoing.
Yes, sir.
అది కూడా unmuted తో echo. సార్ మాట్లాడండి సార్ ఇక్కడ నుంచి.
Hello.
అన్మ్యూట్ చేయండి.
Unmute.
Direct మాట్లాడండి.
Okay.
ఇప్పుడు మాట్లాడండి. హలో. Is the voice audible?
Yes, sir. You are audible, but there is so much echo right now.
How's the audio now? Is the audio better? Clear?
Yes, sir, it's better.
Yes, sir. Better.
Not echoing, right? Now it's clear. My voice is clear.
Yes, sir.
Okay. మీరు
Yes.
మాట్లాడండి సార్.
My audio is clear. Hello.
No, sir.
So,
Is there still an echo?
Yes, sir.
so,
Yes, tell me.
sir, from your device, it is not echoing currently, but from that,
From my device it is echoing, right?
yeah,
Okay, I'll just see.
so,
So is it echoing now also? My voice is not echoing, right?
no, sir.
No, sir. Your voice is clear.
My audio is clear. Hello.
Yes, sir, it's clear.
1, 2, 3. My audio
Yes.
is clear.
Yes, sir.
ಇದು ಉಂಟು ಅಂತ.
Arbitrary demolition of homes. The state governments in Indigo have been demolishing homes of individuals. Is there an echo?
Yes, sir.
Yes, sir.
So, పంచేయండి ఇది కొంచెం ఇంకా దగ్గర పెట్టండి లేకుంటే ఒకసారి కింద పెట్టండి దాని నుంచి దూరం ఉండాలి కదా. How is it now? How is it now?
Sir, it's echoing.
Still echoing.
How is it now? There's
Sir,
an
it's still echoing.
Is it still echoing?
Yes, sir.
What about now?
Sir, it's echoing.
Is it better now?
A little bit, sir.
It's better now.
Yes,
Yes,
sir.
sir.
Okay, I'm just reading a sentence again. Therefore, in the light of the issues raised, arguments as well. It's still echoing, I guess, right?
No, sir. So much echo, sir.
Okay. How's the audio now? My audio is fine.
Yes, sir.
Yes,
Your audio is clear.
How's it now? Is it clear?
Yes, sir.
Is there any echo now?
No, sir.
What about now? Is there any echo?
No, sir.
Okay. So I believe now there's no echo, you're saying, right? So I'm reading full sentences. Please clarify. The demolitions lack unity, uniformity, fairness, making them arbitrary and discriminatory under Article 14. Is it echoing?
No, sir, it's better.
It's not better. Is it echoing? Is my question.
No, sir, it's not echoing now.
Perfectly fine, that means, right?
Yes, sir.
Okay, thank you. So it's audible and visible. Clear? Right?
Yes, sir.
Okay, thank you. Kindly clarify on my audio and video, please. Yes, team, is it audible and visible clearly?
Yes, sir.
Okay, right. Someone just kindly go on the YouTube channel and let me know if the audio and video is clear on the YouTube channel, please. Participants also can go and just check. Yes, what were you all saying? The audio and video is there, right, on the YouTube channel as well?
Yes, sir, it's clear there.
It's
Perfect.
clear on the YouTube channel also. Okay, that's fine then. Thank you. So teams, wishing you all the best. Sir, good afternoon, sir.
Good afternoon. Yes. Anyone has joined?
Ma'am will be joining at in 5 or 10 minutes,
Oh,
sir.
okay. Let her
Thank you so much for joining, sir.
join. No, there is no question of any thanks. Yes. Very good. Okay. So it start only at 2:30.
Yes, sir. We intend to start at 2:30,
So
sir.
I will be ready.
Yes, sir.
10
Thank you.
minutes more is there.
Yes.
Okay.
Okay. నేను బంద్ చేస్తాను బ్యాక్గ్రౌండ్ బ్లర్ చేసేసాను
Yes, sir. My voice is clear, sir.
Yes, sir. It is clear.
Okay, yes, sir.
Okay, sir.
Okay. Hello. My voice is clear, sir. Hello.
Yes,
Okay.
it is clear. It is clear. I would like to tell all of you all that this is the first year this edition is being live streamed on YouTube as well. Thanks to all the finalist teams, they were able to guide me as to how to uh, use the feature. So thank you.
Courtmasters, kindly admit everyone into the room. Pranati, you also kindly do that. And courtmasters are to spotlight the videos of the justices and of the participants, all the participants. So kindly give us 2 minutes. Ma'am is joining, sir.
Okay, okay, okay. Yeah.
Good evening, sir. Thank you so much for joining us.
Good evening.
After last year, we are meeting now.
Right. Yes. Hope you are fine.
Yes, yes.
Yes.
Thank you so much.
Yes.
Yes.
They enjoyed about you.
Thank you, sir. Yes,
Yes.
I came out very successful, sir.
Yes.
Yes.
And she told me that your wife also is a junior. Yes.
He retired and then studied law and
Law, yes.
Yes.
Last time he told me.
Yes.
Yes. Very good.
Thank you, sir. Thank you.
TC 10, TC 24. Yes. So, welcome, dear friends. Young friends.
Yeah, they are very smart. They are very. It will be a very difficult situation for you.
Right. Generation gap will be always there.
No, they are very well versed with the subject and they are presenting it so well.
Youngsters are very studious and very intelligent.
Yes.
Unlike the past generation.
Yes.
Right.
That is true.
They take it very seriously now.
Yes.
Yes. So TC 10, you are from which state?
I am from Hyderabad, sir, but I study in Bangalore.
And what about it, 24?
So we study in Bangalore as well.
Right.
TC is 10 from Hyderabad, but she is studying in Bangalore, it seems.
Bangalore.
Yeah.
Which college?
Christ University, sir.
Christ University. Right. Good. There are a lot of Malayalis there in Christ College.
Yes, sir.
Law College and the other
It's
arts.
dominated by Malayalis.
There is no question of any domination.
No, there are equal number of Kannadigas and equal number of Malayalis in the college.
Right. We are cosmopolitans. Wherever you
Good
go.
afternoon, madam.
Good afternoon, sir.
Good afternoon, madam.
Good afternoon, sir.
Yes. We were waiting for you.
Yes, sir. I was told 2:30 sharp.
2:30, right, sharp. But I ended at 2:15. Yes, ma'am. TC10, TC24, TC10. Yes. Searcher, speaker 1, speaker 2, got question.
Good afternoon to the respected justices and to all the participants and audience. We from the family of Thomas George and Associates welcome all of you all to this final rounds of the 5th virtual moot court competition conducted by the firm in its 5th edition virtually. Now, with the permission of the justices, shall we start the round, sir and ma'am?
Yes.
Yes, you may proceed.
Courtmasters, the floor is yours.
Good afternoon and welcome to the 5th virtual moot court competition conducted by Thomas George and Associates. I request all participants to keep their cameras on throughout the proceedings and ensure that any technical issues may be promptly communicated via the chat box. A warm welcome to our esteemed judges for this session. I am pleased to introduce our first esteemed guest, Honorable Justice S. Nanda Ma'am. Justice S. Nanda Ma'am completed her BA in English Literature from Osmania University in 1990 and LLB from VSR Law College, Bellary in 1993. Justice S. Nanda Ma'am has specialized in constitutional law and has actively practiced for over 28 years, handling various civil, constitutional, criminal, and service matters. She held significant positions such as standing counsel for the Bar Council of India, panel advocate for government departments, and master trainer for the Telangana State Legal Service Authority. Elevated as a judge of the Telangana High Court on 24th March 2022, Justice S. Nanda Ma'am has since authored over 390 reported judgments and demonstrated exceptional judicial acumen. She holds several firsts, including being the first woman designated senior advocate by the Telangana High Court. Notably, she set a record by pronouncing 71 judgments in a single day in 2023 and 76 judgments in 2024. Justice S. Nanda Ma'am is a member of the Commonwealth Magistrates and Judge Association and the International Association of Women Judges, reflecting her commitment to excellence in the judiciary at both national and international levels.
Now, our second esteemed guest for today is Honorable Justice K. Abraham Matthewson. A former judge of the Kerala High Court, hails from Champ in Kottayam district. He earned his law degree from Law College, Thane, under the University of Bombay. Honorable Justice Abraham Matthewson began his judicial career in 1988 as a Munsif magistrate and steadily rose through the ranks, serving as a sub-judge and subsequently as a district judge. He held key positions in judicial training and administration, including the additional director of the Kerala Judicial Academy in 2004, and later as its director from 2010 to 2012. In 2012, he was appointed Registrar of the Kerala High Court and subsequently serves as a district and session judge in 2013. Honorable Justice K. Abraham Matthewson was sworn in as an additional judge of the Kerala High Court on 1st January 2014 and was appointed as a permanent judge on 10th March 2016. After a distinguished judicial career marked by integrity and dedication, he retired on 18th January 2019. Thank you so much for both of our respected judges for joining us today and giving your valuable time to us. Now, with the kind permission of our esteemed judges, I will brief the rule of the competitions.
Yes, go ahead.
Each speaker shall speak for 15 minutes subject to an extension granted by our judges. But I would like to request to our esteemed judges to please keep the timeline in mind. The structure of the proceedings is as follows: that speaker 1 and 2 of the petitioner side, followed by the speaker 1 and 2 of the respondent side. And reply by only one speaker of petitioner and reply to reply as per our honorable judge's discretion. A steady internet connection to be maintained by all the participants. Participants to ensure that cameras are turned on throughout the rounds. Once again, judgments referred to during arguments can be screen shared. In case during the rounds, if there is any internet interruption from the side of the participants, then a 5-minute extension only will be granted, subject to the discretion of our honorable judges. I will be showing the plug cards marking 3 minutes, 1 minute, and a time left, like time's up for the session.
May it please this court, we are now in session. Appearing for the petitioner is team code 10 and appearing for the respondent is team code 24. Team code 10, how would you like to allot your time?
I would be taking 13 minutes while my co-counsel will be taking 15 minutes of the rest of the time.
Sure. And team code 24, how would you like to allot your time?
I will be taking 15 minutes and my co-counsel will be taking 14 minutes.
Sure. With the kind permission of our judges, can we proceed?
Yes, proceed.
Good afternoon to everyone present here. The council seeks permission to approach the bench.
Yes.
The council seeks permission to address the bench as collectively as bench, and when dealing individually as lordships and ladyship.
Yes, proceed.
Yes. I stand before this honorable court to present the petitioner's case regarding the demolition of house based on the alleged involvement of one individual in a crime. To state the facts of the case, we stand here to speak for thousands of voiceless citizens whose lives have been shattered by the abrupt and heartless action of state governments across the country. In the dead of night, homes that sheltered dreams, families, and memories have been reduced to rubble, all in the name of justice or public interest. In some states, the so-called bulldozer justice has targeted citizens accused of offenses, demolishing not just walls, but very dignity of their existence without any due process. Elsewhere, homes built with government approvals where families have lived for decades have been torn down overnight under the pretext of protecting water bodies. These are the same citizens who for years faithfully paid property taxes, electricity bills, trusting the very governments that are now taking away their shelter. So I will be dealing with issue 1, while my co-counsel will be dealing with issue 2. So the issue 1 will be dealt in 4 prongs. First one, whether the writ petition is maintainable. Second, whether the action of the governments in providing speedy justice by way of demolition of houses of alleged criminals is violating the fundamental rights of innocent family members. It is to be noted that the family members are innocent and on the pretext of alleged criminals, and nothing has been proved in court yet. And the third prong is whether demolishing property based on allegations without a fair trial and due process violates the concept of presumption of innocence and the right to fair trial under Indian law. Sub-issue 1, whether the writ petition is maintainable. Article 32 of the Indian Constitution guarantees the right to move this honorable court for the enforcement of fundamental rights. This provision empowers every aggrieved citizen to approach the Supreme Court directly when their fundamental rights are infringed. The petitioners in this case are victims of blatant state action violating their rights under Article 14, 19, and 21, which is to be proven subsequently in my arguments. While the Constitution empowers the Parliament to vest similar powers in other countries, the petitioner submits that in this matter of grave urgency and fundamental right violations, alternative remedies such as approaching high courts and Article 20 under Article 226 are efficacious nor adequate. The sub-issue 2. Whether the action of the governments in providing speedy justice by way of demolition of the houses of alleged criminals is violating the fundamental rights of the innocent family members. The first argument is violation of fundamental rights under Article 21. It is humbly submitted that Article 21 of the Indian Constitution guarantees right to life. Right to shelter is an essential part because it is an essential part of an individual's dignity and life. The right to shelter ensures that no person can be deprived of a roof over their head, especially when you're not accused of any crime. The demolition of a house, in this case, based on the involvement of only one individual, and that is also alleged and nothing has been proven in court, results in the violation of the right to shelter for the other innocent family members who have no connection to the offense. These family members are deprived of their basic right to live and peace and security in their own house, which directly infringes upon their Article 21 rights. The municipal laws, Section 343, Clause 1 of Delhi Municipal Corporation Act, 368 of Delhi Municipal Corporation Act, the proviso of Section 27, UP Urban Planning and Development Act, Section 261, Haryana Municipal Corporation Act, Section 88, Haryana Urban Development Authority, 1977 Act. All the 5 provisions expressly and clearly state that a reasonable opportunity of show cause notice is to be given before demolishing any houses. And the third argument is of rule of law. Rule of law is a fundamental principle under the Indian Constitution. It forms the basic structure of the Constitution. It ensures that all actions of state must be lawful, transparent, and non-arbitrary. But in the case at hand, the demolition of a house without giving prior notice is an example of arbitrary state action where innocent family members are being penalized for the actions of one individual, and that is still not proven in the court. The action is inconsistent with the rule of law as it disregards due process, the presumption of innocence, and the principles of fairness. My fourth argument is colorable exercise of power. The entire concept of colorable exercise of power refers to the misuse or abuse of authority granted by law, where an action is taken under the guise of exercising legitimate power, but for an ulterior, improper, or unconstitutional purpose. In other words, the action of the government appears legal on the surface, but it is in fact a fraudulent or a deceitful attempt to achieve an improper goal. In the context at hand, the demolitions were not being carried out for the lawful purpose of maintaining regulation, but are instead a form of retribution against individuals or communities accused of offenses. It is humbly submitted that if the demolitions were truly intended to enforce the law, the state could have pursued other legal actions such as attaching the property or seizing the property pending a trial, which would still achieve the same desired result. Instead, the government chose to demolish houses as the first and immediate step, bypassing the judicial process and depriving the citizens of their fundamental rights to a fair hearing. My fourth argument is collective punishment. The concept of collective punishment refers to the practice of punishing individuals or groups for the actions of others. Under Indian law, this is strictly prohibited, as each individual is entitled to due process and presumption of innocence. No one should suffer for the alleged actions of another person. In this case, the demolition of the house as a punishment for the alleged crime of one individual in an act of is an act of collective punishment. the entire family, including the innocent family members who have no connection to the alleged crime, which is not yet proven in the court, are straightly punished by the government. This not only violates their fundamental rights, but also goes against the constitutional guarantee that no one shall be punished for the acts of others. The sub-issue 2, whether demolishing property based on allegations without a fair trial and due process violates the concept of presumption of innocence and the right to fair trial under Indian law. The presumption of innocence is a cornerstone of Indian criminal law as guaranteed by Article 21 of the Constitution. It asserts that every accused individual is presumed innocent until proven guilty in a court of law. But in the case at hand, the demolishing of a house based on allegations without any fair trial or judicial review directly undermines the presumption of innocence. This action presumes the guilt of the individual without following the due process. The family members of the accused, who are presumed innocent under the law and are unjustly punished without any opportunity to contest the charges or undergo a fair trial. The right to fair trial is also a fundamental right under Article 21. This right ensures that no individual is subjected to any punitive action such as demolition of property without an opportunity to contest the charges against them. But in the case at hand, the accused and by extension, their innocent family members are deprived of the opportunity to present their case, defend themselves, and contest the allegations in the court of law. The failure to provide such a hearing and judicial scrutiny before taking such a drastic measure of straight demolishing the houses disregards the principles of natural justice and denies the individuals their right to a fair trial under the Constitution. My last argument is of judicial review and separation of powers. In a democracy governed by rule of law, all actions, including punitive measures such as property demolition, must adhere to established legal procedures and be subject to judicial review. Now, the concept of rule of law requires that no person or authority is above the law, and any action must follow the due process and be open to judicial scrutiny. The separation of powers is also a fundamental principle of the Indian Constitution. It ensures that executive, legislative, and judiciary operate independently, each performing their designated functions without overstepping the constitutional boundaries. The judiciary in particular acts as a check on the excessive use of executive power by ensuring that any government action should be in line with the constitutional principles and rights. Judicial review is the process through which courts examine the legality of executive actions and can invalidate those that do not meet legal or constitutional standards. But in the case at hand, the executive's arbitrary demolition of property without judicial review bypasses the essential constitutional safeguard of judicial oversight. When the executive acts without the scrutiny of the judiciary, it undermines the separation of powers and opens the door to the abuse of power. Executive actions that have the potential to impact on individuals' fundamental rights, such as the right to shelter, must be scrutinized by the judiciary to ensure they do not violate the constitutional provisions. To provide the cases in support, we have Indira Nehru Gandhi versus Sri Raj Narayan. In this case, the Supreme Court highlighted that the rule of law is the part of the basic structure of the Constitution, and it emphasized that all actions, including those of the government, must be lawful and cannot infringe upon an individual's fundamental rights. In the case of Gujarat Steel Tubes Limited versus Gujarat Steel Tubes Mazdoor Sabha, the court rejected the concept of collective punishment, holding that no person should be punished for the acts of others. This judgment reaffirms that the state cannot penalize innocent family members for the alleged actions of one individual. Lordships and ladyships, I respectfully submit all my arguments.
Yes.
Thank you. Good afternoon to everyone present here. The council seeks permission to approach the bench.
Yes, granted.
The council seeks permission to address the bench as your lordship and your ladyship.
Yes.
The council will be dealing with issue 2, which is whether the actions of the governments in demolition of the houses of the citizens in the enclosed areas near the water bodies with or without notice permissible under the law. Your lordships, the petitioners bring forth a grave issue of constitutional and human rights violations arising from the government's abrupt demolitions of homes near water bodies. These actions, executed with or without notice, not only undermine the fundamental principles of justice, but also disregard the constitutional guarantees provided under Article 14 and 21. Your lordships, the cornerstone of natural justice is the odi alteram partem principle, the right to be heard. In Maneka Gandhi versus Union of India, this honorable court held that procedural due process is intrinsic to Article 21. Further, in Olga Tellis versus Bombay Municipal Corporation, the court explicitly recognized that even unauthorized occupants have the right to prior notice and an opportunity to defend themselves before eviction. The overnight demolitions bypass these safeguards, rendering the actions arbitrary, unconstitutional, and in flagrant violation of the rule of law. In Maneka Gandhi versus Union of India, the judgment states that the procedure established by law must be just, fair, and reasonable, and not arbitrary, fanciful, or oppressive. In Olga Tellis versus Bombay Municipal Corporation, the court held that even those who occupy public land illegally are entitled to a hearing and a prior notice before eviction. Eviction cannot take place in a manner that renders the affected individuals destitute and homeless without providing alternative housing or rehabilitation. This highlights the procedural safeguards and humane approach required even for unauthorized occupants. The state has over the years tactically approved these settlements. Residents have paid taxes and utility bills, received approvals for constructions, and witnessed public infrastructure being developed in these areas. This behavior constitutes a clear case of state complicity. The doctrine of estoppel, as enunciated in Union of India versus Indo-Afghan agencies, prevents the government from acting contrary to its past assurances. By permitting long-term occupation and now abruptly reversing its stance, the state violates the legitimate expectation of its citizens and imposes undue hardship upon them. In the case of Union of India versus Indo-Afghan agencies, the court held that the doctrine of promissory estoppel prevents the government from acting in a manner contrary to its previous assurances or representations when individuals have acted in reliance on them. This establishes that citizens cannot be penalized for acting on the implicit approvals and permissions granted by the government. And Article 21 of the Constitution guarantees right to life, which encompasses the right to shelter and livelihood. In Shantisa Builders versus Narayan Kimalal Totame, this honorable court affirmed that adequate shelter is integral to human dignity. The evictions executed without resettlement or rehabilitation plans leave families homeless and livelihoods shattered. This gross violation of fundamental rights is further aggravated by the state's failure to ensure alternatives for those affected. In the case of Sandhisar Builders, it was held that the right to life guaranteed under Article 21 includes the right to shelter, which is a basic human necessity essential for leading a life of dignity. This reinforces the rights to housing as part as the right to life. Your lordships, the arbitrariness is an anathema to the principle of equality under Article 14. As held in E.P. Rayappa versus State of Tamil Nadu, the government's actions lack uniformity and clarity in their implementations. Selectively targeting certain areas without transparent criteria not only creates discrimination, but also undermines public trust in the impartiality of the state actions. Such arbitrary measures devoid of fairness violate constitutional mandates. In the case of E.P. Rayappa, court stated that arbitrariness is antithetical to equality. Where state actions is arbitrary, it inherently violates Article 14 of the Constitution. This underpins the argument that arbitrary demolitions violate the right of equality. I would also bring the case of Delhi Development Authority versus Skipper Constructions. State actions must adhere to principles of fairness, reasonableness, and non-arbitrariness to satisfy the requirements of constitutional propriety. This judgment provides a broader principle for the fair conduct of state actions. Your lordships, While environmental preservation is very important, it cannot override the fundamental rights of the citizens. In Intellectual Forums versus State of Andhra Pradesh, this Honorable Court emphasized the necessity of balancing ecological restoration with individual rights. Similarly, in Bhim Singh versus Union of India, the court reiterated the duty of the state to ensure alternative housing during such initiatives. The demolitions in question, devoid of a proportional response or rehabilitation measures, reflect a blatant disregard for constitutional obligations. I would like to bring in the case of Intellectual Forum versus State of Andhra Pradesh. It was held that environmental conservation must be balanced against the fundamental rights of individuals. Displacement requires humane measures, including proper resettlement and rehabilitation. This directly addresses the need to balance environmental protection with individual rights. Also, in the case of Ajay Makan versus Union of India, the right to housing is inherent in the right to life under Article 21. And evictions must not result in homelessness without rehabilitation plans in place. This case further solidifies the need for resettlement prior to eviction. Your Lordships, as a signatory to the International Covenant on Economic, Social, and Cultural Rights, which is ICESCR, India is bound to uphold the right to adequate housing and prevent forced evictions. The UN Basic Principles on Development-Based Evictions mandate prior notice, consultations, and resettlement for affected persons. The government's failure to adhere to these international norms tarnishes India's commitment to upholding human rights. UN Basic Principles on Development-Based Evictions and Displacements give out these principles that adequate and reasonable notice to all affected persons should be given. Meaningful consultations with affected persons prior to eviction should be done. Provisions for adequate resettlement and compensation should be given. Your Lordships, coming to the next point, the government failed to explore viable alternatives in these abrupt demolitions. Measures such as retrofitting the settlements or implementing gradual resettlement programs could have minimalized both environmental harm and human suffering. I would still like to quote Olga Talley's case here. The Honorable Court highlighted the need for rehabilitation as a prerequisite for eviction. The absence of such efforts here demonstrates a lack of due consideration for the rights and well-being of affected citizens. Thus, I would like to rest my case, Your Lordship and Ladyship. Can I proceed with the prayer if you may permit?
One question.
Yes, my Lord. Yes, my Ladyship.
Yes, follow the question. The Apex Court in the judgment reported in 2013, Volume 5 SCC, page 336, in the case of Deepak Kumar Mukherjee versus Kolkata Municipal Corporation and others, held that an illegal construction materially affects rights to enjoyment of property by persons residing in that area, the municipality or the state, are duty bound under the statute to see that the area is not spoiled by unauthorized constructions. How do you answer this precedent of the Apex Court?
Yes, my Lordship. The problem here is it's not proved that it is an encroachment. Overnight, the government is bringing bulldozers and demolishing the buildings. First of all, the notice should be served and it should be made sure that it's an actual encroachment. When people are not getting a chance to be heard, then how do the government prove that it's an encroachment in the first place? If it's really an encroachment, then the government has all the authority to exercise this. But firstly, they should be heard and the encroachment should be proved.
Yes.
So I would like to add one question.
Yes, sir.
Somebody is squatting on a public road. Should notice be issued before he is...
I'm really sorry, Lordship. I couldn't follow the question. Can you please?
Suppose somebody is occupying a public road.
Yes, sir. Public road is a pretty different scenario in this case, because the construction of a house takes a lot of permissions, payment of tax, and also it puts in a lot of capital to build it. So overnight demolition is completely different because a person's lifetime earning is going into this, and also he has got government permissions, government sanctions when he's building this. So when government is trying to demolish something which has happened with all these things, then they'll have to follow a particular procedure, and they should make sure that nobody is put into a bad situation. And we completely understand that environment should always be kept in the first place. But that doesn't mean that government can take arbitrary actions on these people.
So there may be situations, suppose there is a situation where issuing notice will defeat the public interest.
My lordship, I feel that issuing notice is very important according to the principle of adi alteram partem, because it's a principle of natural justice, and everybody should be given a chance to be heard, because they have to be given a chance to put their contentions and prove that it's not an encroachment. If later on, if it's proved that it's not an encroachment, then there is no remedy there, because the government has already demolished the house. And later on, if it's proved that it's not an encroachment, then the compensation will again be a burden on the government itself.
Suppose the special act does not provide for issuing notice.
That happens only in special cases where it's a very grave and urgent necessity. But here the houses have already been.
Exceptions.
Yes, my lord.
There are some exceptions.
Yeah, there are few exceptions, my lordship. But here we are afraid that these demolitions are taking place in a selective basis. And also, it has always been there. From 15-20 years, the government has collected taxes, and also they have given electricity, they have given permission for water pipelines and everything. So when all these years this was not a problem, then they can give notice and hear from their side.
Okay. So council number 1, you said that Article 21.
Yes, Your Lordship.
Council also mentioned Article 21 guarantees the right to shelter. But the right to speedy justice also is guaranteed by Article 21. Speedy justice here means the public. On the one side is the public, the other is illegal occupants, unauthorized occupants. So what about the speedy justice?
Your Lordships, I would put my arguments that speedy justice is important, but the houses of the innocent people are getting demolished here. And then other than demolition also, if the demolitions, I would say if the demolitions are truly intended to enforce the law, the state could have pursued other legal actions such as attaching or seizing properties pending a trial, which would still achieve the desired result. Instead of demolishing the house as a first and immediate step, the government could have attached or seized the property. It would still achieve the same result.
Okay.
Thank you, Lordship.
My question to the first counsel. What if the property was used in crime? Public interest is supreme. Public interest prevails over personal interest. Notice can always be waived. How do you answer that?
Your Ladyship, I would say, here it is alleged criminals and not the criminals who are proven, who are not guilty in the court. So it is still, there is a chance of the criminals being innocent. And even if the house is used for an illegal action, it is not proven in the court yet.
Yes.
Thank you, Ladyship.
If your lordship and ladyship permit me, can I proceed with the prayer?
Yes, proceed.
Proceed.
Thank you. Wherefore, in the light of issues raised, authorities cited, and arguments advanced, the Honorable Supreme Court of Indigo be pleased to declare the actions of state governments in demolishing the houses of alleged criminals with or without notice as violative of constitutional rights, particularly the principles of natural justice and the right to shelter. Direct the governments to immediately halt further demolition activities near water bodies or elsewhere without adhering to proper procedures, including prior notice, public consultation, and rehabilitation plans for affected citizens. Mandate the governments to devise and implement comprehensive policies for regularizing long-standing residential constructions in enclosed areas, ensuring accountability for prior permissions and taxation while balancing environmental protection imperatives. Award compensation of at least 10 lakhs or whatever may be the value of the land if they are proved not guilty to each affected family whose homes have been demolished without due process to redress the material and psychological harm caused by the state government's actions, and or pass any other order it may deem fit in the interest of justice, equity, and good conscience. Thank you.
Yes.
If your lordships and ladyships give me the permission, may I begin?
Yes.
Yes.
Counsel seeks permission to approach the dais. Counsel seeks permission to address the bench as your lordship and ladyship.
Granted, yes.
Much obliged. This is counsel 1 from the side of the respondents and will be dealing with the first issue, while my co-counsel will be dealing with the second issue. Your lordship and ladyship, if you all are well versed with the facts, may the counsel proceed with submissions.
Yes, proceed.
Much obliged. Your lordship and ladyship, the council will be dealing with the first issue, which is whether the actions of the government in providing speedy justice by a way of demolition of houses of alleged criminals with or without notice is permissible under the law. Your lordship and ladyship, the council will be dealing with the same under 3 limbs. Firstly, doctrine of necessity and property rights. Secondly, the demolition of houses linked to these alleged criminals as a necessary deterrent. And thirdly, your lordship and ladyship, the legal maxim, which is ex turpi causa non oritur actio. Moving on with my first limb, your lordship and ladyship, which is the principle, the doctrine of necessity and property rights. It is most humbly submitted that the government's action to demolish the houses of these alleged criminals is constitutionally justified and grounded in the principles of doctrine of necessity and the relative nature of property rights. Your lordship and ladyship, it is humbly submitted that the government's action in demolition of the houses of alleged criminals is justified under the doctrine of necessity, which permits the actions that may otherwise be considered excessive very well, if they are very well essential to prevent some urgent threat or prevent greater harm to the society. The Honorable Supreme Court in J. Manopatra versus the State of Orissa, which your lordships will and ladyships will find on page 14 of this compendium, recognized that the doctrine of necessity can be used in administrative actions as well. Your lordship and ladyship, it is to be noted that these demolitions were done safely. The petitioners nowhere have contended that any person was hurt or any citizen was caused grave harm. Your lordships and ladyship, as the petitioners themselves said, this was a very targeted action. We have done our due process, we have done our due research, and your lordship and ladyship, only the houses of the people who we know were criminals have been demolished. In this case, the demolitions were carried out as a measure aimed at curbing the criminal influence and preventing further crimes from occurring. Properties associated with these alleged criminals often serve as a hub of illegal activities, or they are associated with symbol of unlawful power, creating an environment of fear and undermining the public's trust in the government, your lordship and ladyship. By demolishing these properties, the government seeks to dismantle the infrastructure supporting criminal behavior and disrupt potential sources of continued crime. Your lordship and ladyship, we also submit that it is the government's duty to protect the larger society, according to the doctrine of parens patriae, as stated in the case of Charan Lal Sahu versus Union of India, which your lordships and ladyships will find on page 54 of this compendium.
Yes.
The court emphasized that the deprivation of individual rights was sometimes necessary for achieving larger public welfare and addressing needs. Your lordship and ladyship, it is also submitted that these actions were not taken without any foresight or planning. The government is looking into various provisions to relocate the affected individuals to areas where their activities can be more efficiently regulated, thereby balancing the immediate public threat as well as their individual rights. Moving on, your lordships and ladyships, to the relative nature of property rights. Your lordship and ladyship, it is further submitted that property rights under the laws of indigo are not absolute, but they are subject to the broader principle of public welfare. It is further submitted that Article 38 of the Directive Principles of State Policy emphasizes the state's duty to protect the welfare of the people and to secure social justice. Your lordship and ladyship, this honorable court in Jilubhai Nanbhai Kachar versus the state of Gujarat, which you all will find on page 17 of the compendium, held that property rights are subordinate to the needs of the society, particularly when the state acts in pursuit of a legitimate public purpose. Your Lordship and Ladyship, the demolitions in this case are not arbitrary. Rather, they are a targeted measure to neutralize social harm and to restore the public's faith back into the rule of law. Your Lordship and Ladyship, moving on with my second limb, which is demolition of houses linked to alleged criminals as a necessary deterrent. It is most humbly submitted that the government's decision to demolish the houses of alleged criminals is justified under the doctrine of deterrence. This measure aims to prevent unlawful behavior by illustrating the tangible consequences of criminal conduct, fulfilling the state's constitutional responsibility to protect society from harm and to deter future illegal activities. Here, demolition of properties are not merely the physical assets, but they're symbols of criminal dominance and fear, perpetuating lawlessness and impunity in the society. Their removal serves a dual purpose, Your Lordship and Ladyship. Firstly, as a specific deterrence that directly impacts the individual who's alleged of these crimes, and secondly, as a general deterrence, as it discourages others from engaging in similar behavior by demonstrating the consequences of unlawful conduct. By targeting properties linked to alleged criminals, the government underscores the unacceptability of such behavior and reinforces societal trust in the rule of law. Further, Your Lordship and Ladyship, it is submitted that the executive has the authority, that the executive authority of the state in the executive respect has been enumerated in list 2 of the 7th schedule. Entry 1 of the state list, the 7th schedule of the Constitution, gives the power to the state to legislate on public order. Hence, this includes the authority of the state to take necessary steps, such as demolitions, to maintain public order. The government's actions are therefore legally grounded and constitutionally valid. These actions are neither arbitrary nor excessive, but they're preventive and proportionate measures aligned with the larger interest of the society, addressing both immediate threats and long-term societal concerns. Your Lordship and Ladyship, as you all might have been very well aware, that there are certain theories of punishment. Now the council will prove how demolitions is very well considered under all of these theories, Your Lordship and Ladyship. If we take firstly the deterrent theory of punishment, using demolitions, like public demolitions, serves as a visible warning to potential offenders. Second is the retributive theory of punishment. This directly punishes the offenders by removing their property, Lordship and Ladyship, and it inflicts proportionate harm equivalent to the alleged criminal crime. Your Lordship and Ladyship, third, we have the preventive theory of punishment, which disrupts criminal networks and infrastructure. In this case, we're disrupting the hub itself of the criminals, and hence we are preventing future harms from being carried out. Moving on to my last limb, which is the maxim of ex turpi causa non oritur actio. Your Lordship and Ladyship, it is humbly submitted that the government's action in demolishing houses linked to these alleged criminals are justified under the principle of ex turpi causa non oritur actio, which asserts that no legal rights can arise from an illegal act. As held in the case of Narayamma versus Govindappa, which Your Lordship and Ladyship will find on page 46 of the compendium, individuals cannot derive legal or procedural advantages from unlawful conduct. In this case, we assert that they were related to some sort of unlawful conduct, and hence, Your Lordship and Ladyship, they cannot ask for enforcement of any legal right that may have been violated. The demolitions ensure that no unlawful act or its proceeds is allowed to persist, effectively dismantling hubs of fear and criminal influence while restoring public trust in the governance. Safeguards within the constitutional framework also provide for adequate redressal measures, allowing affected individuals to challenge these demolitions order, present their evidences, or to seek compensations if their rights have been found to be violated. And hence, Your Lordship and Ladyship, the actions of the government in providing speedy justice by a way of demolition of the houses of these alleged criminals is permissible under the law. And if the bench is satisfied, the council would now like to call upon the co-counsel to deal with the second issue.
No, you answer this first.
Yes, Your Ladyship.
Yes. Are you able to hear?
Yes, Your Ladyship.
Demolishing houses of persons on the ground of their alleged involvement in crimes would amount to inflicting collective punishment on the family, which is impermissible under the constitution scheme and the law. What do you say about this? Doctrine of proportionality, doctrine of rule of law are not followed by the government. How do you answer this?
Indeed, Your Lordship and Ladyship. Indeed, Your Ladyship. So, firstly, Your Ladyship, the council would like to reiterate its point, which said that the petitioners nowhere contended that any harm was caused to the family, which means, Your Lordship and Ladyship, that the government has taken this action with all the due care and process required. Your Lordship and Ladyship, secondly, we are looking into reallocation, rehabilitation of these individuals. And hence, we contend that no such right. In fact, Your Lordship and Ladyship, we contend that their Article 21 was also not violated because we are providing them with rehabilitation further, Your Lordship and Ladyship. Their right to shelter is not being violated since we will provide them with rehabilitation. This demolition measure is what we are contending. And we contend that it was not illegal as all due precaution was taken before this demolition had happened. And it was only done to showcase to the society that if anybody engages in any sort of criminal conduct, there will be tangible consequences, Your Lordship and
Ladyship. Can houses be demolished even without trial? Which case law permits this?
Your Lordship and Ladyship, here the houses were demolished, we agree. But Your Lordship and Ladyship, we have the executive has done its due diligence and we have reasonable and we have more than enough proof to understand that people residing in these areas are people who have some connection with criminal influence. Either they are parts of they're doing criminal activities inside of their house or they're related to some sort of criminal activities. And hence, this is a measure that has been taken for speedy justice.
And under criminal law, accused is not guilty unless proven guilty. How do you answer this?
Indeed, Your Lordship and Ladyship, we answer this by stating that firstly, we assure you that any of the houses that have been demolished are the houses of criminals. And if there is a possibility, a semblance of possibility that we are wrong, we again state that there are other redressal mechanisms that can be taken. Like Your Lordship and Ladyship, in this hearing right now, this is audio altrum partem. We are listening to both of the sides, Your Lordship and Ladyship. So hence we state that even natural justice is not violated.
So who will judge whether they are criminals or not? Bureaucrats or the judiciary?
Your Lordship and Ladyship, we have, as we already stated, we have more than enough knowledge and information to understand that these people are criminals and have participated in criminal activities.
So the Constitution has entrusted the duty of administration of justice to bureaucrats or the judiciary.
Your Lordship, the judiciary definitely has the power, and we, as the council already stated, that now this is the time when we are here for the judiciary to exercise its power. If we are proven, as the council already stated, that we have more than enough knowledge that these people are criminals, and Your Lordship, this was a step taken so as to work with the judiciary and not against the judiciary.
Okay. Assume that this occupation is unauthorized. Can an unlawful act be undone in an unlawful manner by the government?
Your Lordship, that is exactly what we are contending, that there was no, this is not an unlawful act as no fundamental right was violated, Your Lordship. If the petitioners are contending that their right to shelter was violated, we are saying that we will give them rehabilitation. Their right to shelter will not be violated.
Fairness in procedure also is guaranteed by Article 21.
Your Lordship.
It is substantive law. Procedural law also should be fair.
Your Lordship, this was definitely fair. As we already stated, that this served as a measure of deterrent punishment. We also stated that different theories of punishment via which the actions of demolitions are justified.
Which law gives you the right to impose punishments?
The executive, Your Lordship.
Executive, sir.
Your Lordship, the executive, the Constitution, as the Council stated, state list, the seventh schedule gives the executive the power to maintain state order, Your Lordship, as well as our directive principles of state policy give us the constitutional power to maintain public safety and order, Your Lordship.
The time is up. Okay. Good.
Much obliged, Your Lordship. It was a pleasure arguing before this court.
Yes,
Your Lordships, the Council seeks permission to approach the dais.
yes, permitted.
Your Lordships, this is the Council representing the respondents on issue 2, that is, whether the demolition of houses of citizens in the enroached areas near water bodies with or without notice is permissible under the law. The respondents submit that the demolitions were lawful and constitutionally valid, carried out to uphold environmental norms, enforce statutory duties, and prevent further encroachment in the buffer zones. Your Lordship and Ladyship, the Council will begin with the first limb, that is construction, prohibition of construction in buffer zones. Your Lordship and Ladyship, buffer zones are critical for ecological preservation, acting as safeguards around environmentally sensitive areas. These zones are not arbitrarily designated, but they serve for an important factor, that is the protection of the environment. And they also serve several essential functions such as mitigating flooding risks and protecting water quality and ensuring ecological stability. The same was also reaffirmed in Monthly Tech Zone Private Limited versus Forward Foundation, that buffer zones must be designated as no construction zones. And the same can be found in para 60, page 24 of the compendium. Furthermore, Your Lordships, in Karnataka Industrial Areas Development Board versus C. Kenchappa, the Honorable Court emphasized that the state bears a duty to protect the common heritage of lakes, streams, and marshlands for present, and not only for the present, Your Lordship and Ladyship, but also for the future generations. This judgment highlights that principle of sustainable development, which demands a fair balance between the development as well as environmental preservation. It is crucial to recognize that the needs of the present cannot be fulfilled at the expense of the future generations. So this environment is not only for the protection of the present generations, but also for the future generations. And there must be a fine line drawn between the protection of the environment at the cost of fundamental rights which have not been violated here. The houses in question, as admitted in para 5 of the Moot proposition, these houses were constructed within the buffer zones, within these very buffer zones, Your Lordship, violating the established precedents. These constructions compromise the very purpose of buffer zones, that is to ensure ecological stability and prevent flooding. Even in Tata Housing Development Co. Limited versus Alok Jagga, this Honorable Court stressed on the necessity of preserving buffer zones to maintain sustainable development. Allowing encroachments in such areas jeopardizes public safety and also sets a dangerous precedent for unchecked environmental violations. Moving on to the next limb, that is regularization of unauthorized structures, and firstly, Your Lordships, the petitioners contend that their properties should be regularized based on two major grounds. Firstly, payment of property taxes and utility bills. Secondly, the long-standing possession. However, Your Lordships, neither of these grounds can validate illegal constructions. In Mahendra Baburao Mohadik versus Subhash Krishna Kantikar, this Honorable Court itself has held that payment of property taxes or utility charges do not confer any sort of legal rights or ownership. These payments are just administrative in function for revenue collection and public service facilitation, to serve to maintain infrastructure and services, and further, they do not legitimize any sort of unauthorized structures. Furthermore, Your Lordship and Ladyship, the second contention, that is the long withstanding possession, in the case of Jagpal Singh versus State of Punjab, it was held that the encroachment, regardless of their duration, cannot be legitimized. Time does not convert illegality into legality. To regularize such constructions would not only deepen the harm caused but also encourage future violations. Similarly, in the case of Isha Ekta Apartments, a housing society limited versus Municipal Corporation of Mumbai, this honorable court has also emphasized that unauthorized structures must not be regularized, as doing so undermines the planning and encourages lawlessness. Furthermore, your lordships, the government cannot be forced to act to regularize these houses, especially because of two reasons. Firstly, as upheld in the case of Shri Sidbali Steels Limited versus State of UP, it was held that the government cannot act in violation of any law as such. In this case, the buffer zones are no construction areas. Moreover, your lordship, the government cannot act in violation of protecting the environment. The government is mandated to protect the environment. Moreover, in your lordship's public interest must prevail over individual gains, and the same was upheld in STO versus Sri Durga Oil Mills. This honorable court held that government could retract from its representation in case of overriding public interest. Validating these constructions only compromise environmental sustainability and encourage further encroachments, jeopardizing the larger public good. The respondents, hence, have acted decisively to rectify past lapses and to uphold environment as their main priority and outweigh any private expectations, your lordship. Thirdly, constitutional mandate to protect the environment and public trust doctrine. Your lordship's environmental protection is not merely a statutory duty, but a constitutional mandate that has been imposed on the state governments under Article 48A. It directs the state to protect and improve the environment, including forests, rivers, lakes, and wildlife. This provision embodies the principle that environmental preservation is fundamental to ensuring well-being of the larger public, your lordship. Similarly, in the case of MC Mehta versus Kamal Nath, the public trust doctrine was laid down, which imposes a fiduciary responsibility on the state to safeguard the natural resources for public use and ecological preservation. In this, a trusteeship is given to the government of all natural resources, and the government has a duty to protect such natural resources, your lordship and leadership. Water bodies, rivers, lakes, and rivers are held in trust by the government for the benefit of the people. Encroachment within the buffer zones violate this trust and necessitate corrective measures to restore the ecological balance and prevent irreversible harm. Moreover, further reiterating the point of ex turpi causa non oritur actio is that no action arises from a dishonorable cause. Here, your lordships, in this present case, the petitioners themselves have violated the laws by encroaching a certain buffer zone areas, and now they cannot ask for any, state that environmental protection cannot be given importance over their individual rights. Moreover, your lordship, coming to the last limb of that is, notice is not compulsory for public places. In the present case, it is the buffer zone, which is a very ecologically sensitive area that has been encroached by the petitioners, and hence, your lordship, to prevent any more damage to the environment, and it was an immediate situation due to the various flood-like situations that were rising, and hence it was a very immediate threat to the very existence of the petitioners as well, and hence the notice was not given. Additionally, your lordships, in Almitra Patel versus Union of India, this honorable court emphasized the need for expeditious removal of encroachments when environmental concerns are at stake. The demolitions hence were not arbitrary but carried out to avert long-term ecological damage and uphold public welfare. Your lordships, this immediate action was essential to prevent the continued degradation of buffer zones, protect public safety, and fulfill the state's constitutional obligations. While procedural safeguards are crucial, they must not become tools to delay corrective measures in matters of overriding public interest. If the bench is satisfied with the arguments, the council would like to move ahead with the prayer.
But before you go to the prayer, one question to you. Right to shelter is the fundamental right of every citizen. And
Indeed,
even encroachers are protected from state action, which violates procedure established by law. As a means of delivering speedy justice, can the state go ahead with these demolitions illegally?
Indeed, Your Lordship, what the respondents are trying to contend is that there has been no violation of the Article 21 right to shelter. The demolitions were done to protect the environment. They will be given appropriate rehab and other housing measures, Your Ladyship.
So, where a statute is silent about the principles of natural justice like notice, the Supreme Court has held that principles of natural justice should be read into every statute, even when, even where the statute is silent. So, are there not, are these occupants entitled to these principles of natural justice?
Indeed, not, Your Lordship. So, in the present case, it was very important that these houses are demolished because they were exerting an unnecessary pressure on the environment, which were creating flood-like situations.
So, can in the name of protecting this public interest, injustice be done?
It is not injustice, Your Lordship. Moreover, the council would like to contend that it is justice for the rest of the people, and the encroachers themselves have ignored the law. Have ignored
people means majority.
Not the majority, Your Lordship, but the larger public interest.
Yes.
And Your Lordship, the petitioners themselves have ignored the law, and then they themselves are in the wrong. And moreover, ignorance of law cannot be pleaded as a defense, Your Lordship.
Yes.
But government stayed silent for a long period. Government allowed the registration. Government allowed the encroachments.
Indeed, Your Lordship, indeed, Your Ladyship, they gave the necessary permissions. Moreover, the petitioners also have ignored the law. And again, coming back to the council's point, ignorance of law cannot be taken as a defense by the petitioners, even though the state has given them necessary permissions. And taxing does not confer any legal rights as such. It is merely administrative in nature. All these functions are only administrative in nature.
Yes.
Shall the council move forward with the...
One more question.
Indeed, Your Lordship.
Article 21 takes off this speedy justice. But what about instant justice?
What about, sorry, Your Lordship?
Instant justice. Instant justice.
Instant justice.
Speedy justice. Article 21 only guarantees speedy justice, not instant justice. So can you, in the name of justice, can you do it overnight?
Indeed, Your Lordship, because this is also a form of speedy justice. If you look at it, it was only in this action has also protected the petitioners in one way, because the flooding would have also been fatal to them if not. By demolishing their houses, it has not only averted the flood-like situations, but has also protected the petitioners, Your Lordship.
Okay.
Much obliged, Your Lordship. Wherefore, in the light of the issues raised, authorities cited, and arguments advanced, the Honorable Supreme Court of Indigo be pleased to declare that actions of the respondents in demolishing houses of alleged criminals with or without notice as lawful and valid, the state's discretion to take necessary measures, including the demolition of properties to ensure compliance with environmental norms and the prevention of enforcement in buffer zones, and the petition be dismissed, and or pass any other order that this honorable court may deem fit in the interest of justice and equity, all of which is humbly and respectfully submitted. Counsel, on behalf of the respondents, it was a pleasure arguing before this court.
Yes, judgment reserved.
Sorry, Your Ladyship?
I said judgment is reserved.
Thank you. Much obliged, Your Ladyship.
Your Lordships, the Respondent Council has presented several arguments justifying the actions of government. If you allow me, I would address the rebuttals for the case.
We'll permit the rebuttals for 5 minutes.
Much obliged, Lordship.
Yes.
So, Your Lordships and Ladyship, it is to be noted that the respondents said they're gonna compensate or provide rehabilitation. But it is to be noted that demolishing of a house is not demolishing just walls, it is also demolishing of a roof over the heads of innocent people who are not yet proven guilty in the court. So it is still a loss. There can be no tangible amount that can be attached to rehab to the house that has been built on the hopes of the family and shattered in one night. And it is also humbly submitted before the court that if the alleged criminals are assumed to be on the run, demolishing their homes only incentivizes them to flee further, making it harder for the government to locate and apprehend them. This approach undermines law enforcement efforts by disrupting communities and creating more public disorder rather than reducing the public disorder. Your Lordships, the respondent invokes the doctrine of necessity to justify the demolitions, arguing that extreme and immediate public welfare concerns are warranted such actions without alternative remedies. Your Lordships and Ladyship, the doctrine of necessity does not grant blanket immunity to actions violating rights. The doctrine of necessity applies only in circumstances of imminent emergency where there are no alternatives exist. Here, the government had multiple lawful options, like attaching the property rather than or pursue judicial proceedings rather than directly and immediately demolishing the houses overnight. The principle of proportionality requires that state actions must be the state actions be the least restrictive means to achieve public interest. Demolitions or other acts causing substantial harm to the individuals must be proportionate. The respondents argued that demolishing properties linked to alleged criminal acts as a deterrent and serves the public interest. Your Lordships, punitive demolitions without due process erode the very foundation of the rule of law, as noted in the case cited by the respondents, that is Premchand Garg versus Excise Commissioner. The doctrine of deterrence must operate within legal boundaries. Arbitrary actions only polarize society and foster mistrust in state mechanisms. Furthermore, the state actions must meet the proportionality test. Blanket demolitions based on mere allegations disproportionately harming the innocent individuals, and it undermines the constitutional guarantees. The respondent invoked the principle of ex maleficito non articular actio to argue that individuals engaged in criminal acts cannot derive rights from the wrongful act. Your Lordships, the principle does not negate the fundamental presumption of innocence until proven guilty. The procedural safeguards remain paramount even in case of allegations. It is mere allegations and not yet been proven in the court to demolish the houses of criminals. Even if it is in the court, it is at the discretion of the court to decide what has to be done, rather than directly on overnight demolishing the houses. The respondents claim that constructions and buffer zone violate environmental laws, citing judgments such as Monthly Tech Zone Private Limited versus Forward Foundation. Your Lordships, while environmental protection is critical, these constructions were allowed to persist due to the government's administrative negligence. Citizens build their home relying on the absence of enforcement and regulation. Retrospective demolitions without due process are unjust and arbitrary, as they violate the legitimate expectations of the residents. It is humbly submitted that the respondents argue that the payment of taxes and utility bills does not validate unauthorized structures, citing Mahendra Babu Rao Mahadik versus Subhash Krishna Kanitkar. Your Lordships and Ladyship, while the principle is acknowledged, the state's continuous acceptance of taxes and provision of utilities creates a legitimate expectation among the residents that their dwellings are lawful. As per the doctrine of legitimate expectation, the state cannot retroactively invalidate these structures overnight, directly demolishing without giving them the opportunity to be heard. The respondents also claim that the demolitions were necessary to enforce constitutional mandates under Article 48A for environmental protection. Your Lordships and Ladyship, The doctrine of public trust cannot justify arbitrary actions that displace citizens overnight without balancing fundamental rights under Article 21. It is to be cited that in Olga Terrace versus Bombay Municipal Corporation, this honorable court emphasized the need for procedural safeguards like notices and hearings, even when public interest is evoked. The state failed to provide alternative housing or support to those displaced, violating principles of sustainable development and socio-economic justice under Article 39, Clause P. Your Lordship and Ladyship, just if I could get an extra minute, I would just end my arguments.
Yes, proceed.
Yeah, thank you, Your Lordship. Your Lordships, in summary, this is not just a legal issue, Your Lordship and Ladyship. It is a humanitarian crisis. Children have been left without a roof over their heads, elders without a place to rest, and entire families without hope. These demolitions are not just demolishing houses, they are demolishing lives and hopes of the families, innocent families who are not yet proven guilty in the court. Your Lordships, and Ladyship, while the government claims to act in the public interest, its actions fail to meet constitutional and legal requirements. Arbitrary demolitions without notice or due process sets a dangerous precedent, undermining the rule of law. We pray that this honorable court upholds the principles of fairness and justice by declaring these actions unconstitutional. Thank you, Your Lordships and Ladyships. It was a pleasure arguing before this court.
Your Lordships and Ladyships, if we could have a minute or two for rebuttals.
There cannot be a reply to a reply. Judgment reserved. Yes.
Your Ladyship, it is permitted if your Lordship and Ladyship permit.
Not permitted. Judgment reserved.
Much obliged.
We thank our honorable justices. Now I shall be shifting honorable justices to the discussion room for the purpose of marking. Kindly click the link, sir, so that you can join the room. Ma'am, kindly click the link, ma'am, to join the room.
Yes.
പഞ്ചലി ചോദിച്ചോണ്ട് ഇല്ല പോയപ്പോ 31 ഉണ്ട് 33 ആക്കിയായിരുന്നു ബാക്കി എന്തോ പഞ്ചറുണ്ട് ഞാൻ പോയപ്പോ പഞ്ചറടിച്ചു I found their systematic are fully involved. And 5, 6, 7, 8 classes. Church also. എവിടെ പോവാനാ അല്ല കോലില്ല ഇല്ലട കോല് കിട്ടി ആ What picture? No, no, Kubika.
I request Thomas sir and Nirmala ma'am to kindly switch on their cameras.
I'm screen to be.
Yes, madam, it's very nice to see you again. After a
Namaste,
few
sir.
years.
Namaste, madam.
Yes. Very good. Your son told me that you are a junior to your son.
Yes, sir. Tables have turned. I used to teach my son when he was small. Now
Yeah.
he's me. And I'm
It is the other way
enjoying
about now.
it.
Yes, right.
Ma'am, you're on mute. Yes.
I also came to know that you were successful in 2 cases recently as a counsel.
I'm being trained by Manav, madam.
Yeah.
We have an active discussion at home.
Yeah, right.
Before we argue, and I put in all my doubts as to what are the aspects, and then he helps me out.
With the permission of your lordships, we would like to commence the valedictory ceremony. Good evening to the respected dignitaries virtually present today and the dignitaries who have been part of the previous rounds. Good evening to the participants, the volunteers, the members of the firm, and my beloved audience. A warm welcome to the valedictory ceremony of the 5th virtual moot court competition conducted by Thomas George and Associates. Coordinators are requested to please mute all the audience. Today we have been witnessing a very unique proceeding with honorable justices reserving the judgment on the most recent decision and discussion of bulldozer justice. In the recent era, we have seen governments taking steps overreaching their doctrine of separation of powers. Furthermore, in this year's edition of the competition, we had witnessed 23 teams participating in different. We have been sorry for those interruptions. I would like to state that this year we had witnessed 23 teams that had registered, comprising 3 students in each approximately. There were 65 to 70 students for this particular competition from different law schools spanning throughout India. In this competition, I am welcoming all of you all. We had the great privilege of Honorable Justice Kurian Joseph Sir for gracing this occasion in 2021 and His Lordship K. Abraham Matthew Sir for gracing in the year 2021 for the first time. In 2022, we had the privilege and honor for late Honorable Justice Thottathil Radhakrishnan Sir for gracing this ceremony and for gracing the inaugural ceremony of the competition. And we had the opportunity of Nanda Ma'am, Honorable Justice Telangana High Court, Honorable Justice Mummaneni Sudhir Kumar Sir for the 2022 edition of our Moot Court. In the previous edition conducted last year, we had the opportunity of Honorable Justice A. Hari Prasad Sir for gracing the inaugural ceremony, and we had the opportunity of Honorable Srimati P. Sri Sudha, Justice High Court of Telangana, and Honorable Justice Suripalli Nanda Ma'am for gracing the finals of the previous edition. Today, I welcome Honorable Justice Suripalla Nanda Ma'am for this round, and I also welcome Honorable Justice K. Abraham Matthew Sir. Before I would like to invite Honorable Justice Suripalli Nanda Ma'am for her speech, I would like to give a brief introduction of Ma'am's profile. Honorable Mrs. Justice Suripalli Nanda Ma'am was born on 4th April 1969 to late Dr. Bolaram Danappa, who worked as a government doctor specialized in ophthalmology and retired as Deputy Civil Surgeon, the government erstwhile composite state of Andhra Pradesh, and late Srimati Bolaram Meera at Gaulipura. Ma'am had obtained a BA Literature from Osmania University, Hyderabad in 1990, and she had obtained her LLB special degree from VSR Law College, Bellary in 1993. Her ladyship enrolled as an advocate on 4th August 1993 and joined the offices of Honorable Justice G. Chandraya Garu, and thereafter worked as a junior counsel assisting V. Rajgopal Reddy Garu, the then senior advocate from 1994 to 2000. Ma'am was also a member of the AP High Court Legal Services. She was appointed as a panel advocate for the AP High Court Legal Services Committee. She was also holding the assignment of Master Trainer from the state of Hyderabad, Telangana to train legal aid panel lawyers for all the districts. Ma'am was also in the panel of the Bar Council of India, defending the Bar Council of India as its sole counsel since 2000 until elevation. Ma'am worked as assistant government pleader for land acquisition. Ma'am was also appointed as a standing counsel for the Bar Council of Andhra Pradesh in 1995 and continued as a panel advocate for the Bar Council of Telangana and AP in all the pending matters until elevation. Ma'am is the first woman to be designated as a senior advocate in the High Court of Telangana. She has many first accolades to her credit. She was the first woman designated in the history of the erstwhile composite Andhra Pradesh state to have been appointed as a judge. She was the first woman from the Telangana Bar to have been elevated as a judge to the Telangana High Court. She was the first woman advocate who had served the esteemed Bar Council of India as its standing counsel for more than 2 decades in the Telangana High Court and erstwhile AP High Court. Ma'am was also the first judge from the Telangana and AP High Courts to have pronounced separate judgments in 71 cases on a single day on 5th June 2023 when the High Court reopened after summer vacation. And ma'am was the first judge from the High Courts of Telangana and AP to have pronounced separate judgments in 76 cases on a single day on 3rd June 2024 when the High Court reopened this year. Ma'am was also recipient of the Acharya Chanakya Sadbhavna Puraskar Award in 2010, and ma'am was also the recipient of the National Unity Award in 2020, earmarked for legal field awarded by Telangana Citizens Council, a social service organization. With this detailed and illustrious background, I would like to invite Honorable Justice Suryapalli Nanda ma'am to come forward and address the gathering.
Good evening, one and all.
Good evening, ma'am.
I'm happy to be part of this momentous occasion and deliver the valedictory address at the 5th Virtual Moot Competition 2024, organized by respected Srimati and Sri Thomas George and Sri Manav and Associates. I'm happy to hold this valedictory session and also this event along with my brother from Kerala, Honorable Justice. One of the most appropriate and novel methods of imparting legal education is the concept of clinical legal education. Like an engineer or a doctor, a lawyer too needs to get practical training in order to serve the society to the best of his or her capacity and capability. Moot courts today have become an integral part of legal education. They bridge the gap between theory and practice of law and enable the prospective entrants to the bar to equip themselves with the basic requirement of the court craft and court culture. Knowledge without practical learning is fire without light. Such competitions prune the natural abilities of the budding lawyers like natural plants. Ed Ho, a famous American novelist, said, and I quote, "A theory is no more like fact than a photograph is like a person. Practice makes one perfect, and with lawyers, it is most likely to make them rich as well." I'm of the firm belief that moot court competitions foster confidence, promote teamwork, and refine public speaking abilities, which are essential attributes. Whether you want to become an aspiring advocate, whether you want to become a member of the judiciary, or you want to be an academician. Dear students, the moot court competition, therefore, is a unique opportunity to learn under supervision, to enable you to think and act like a lawyer. It would help you to understand the legal profession and the lawyering process more effectively, and to get acquainted with the art of researching on a given problem and imbibe the ability to master the facts, skills of drafting and arguing the case by application of law. Young friends, I congratulate you all for having chosen a promising career and shall be glad to share a few practical tips which may go a long way while you enter the portals of court. The first and the foremost, never cease to be a student. The lawyers as well as the judges are eternal students of law. A degree in law merely gives one a platform to stand on and begin the journey. Law is never static. It is rather an ever-changing, vast and complex subject. Always keep abreast of the latest legal position, master the facts, and do your homework meticulously. Language is the dress of thoughts, and words are the most powerful drug used by mankind. Have a good vocabulary and use it well and carefully. Mark Twain emphatically said, and I quote, "The difference between the almost right word and the right word is really a large matter. It is the difference between the lightning bug and the lightning. To understand others and be understood by all, know the big words, but always use the small words. Don't get carried away by the sound of your own voice. Be brief. Brevity, as Shakespeare said, is the soul of wit. Let your argument be short, comprehending much in few words. Be punctual. A lawyer who is available to the court and to his client is a great asset. Be sincere and never ever change your sincerity. It is difficult but not impossible to conduct strictly honest business. An advocate is the officer of the court and must make an endeavor to maintain the dignity of the court, to assist in the case of justice without ever creating any obstruction therein should be your primary duty. Never be afraid of the competitors out there. Competition brings out the best in people. Don't let initial failures intimidate you. Fight a good fight and never be in an undue haste. Be patient. Remember, there is always room at the top. The road to success is always under construction. There are no shortcuts if you want to reach the promised land. You must go through the wilderness. Resolve to take fate by the throat and shake a living out of her. But none of the secrets of success shall work unless you do. If you have talent and work hard, and long anything in the world can be yours. Dedication to profession, hard work, integrity, candidness with the client combined with pleasing manners, fluency of language, ready wit, courtroom tactics, patience, confidence, and decent boldness makes a successful lawyer. A law student must read the entire judgment minutely and should not make any opinion by just looking at the title. And interdisciplinary extensive reading is also a prerequisite for becoming a successful lawyer. A lawyer must first of all be a cultured human being. Lawyers should draft sound propositions. Legal profession is a service-oriented profession, and it is a lawyer's duty to lead the clients to the channels of wisdom. My elderly advice to all who are ready to take the big plunge is adhere to truth and uphold dharma, justice and rule of law. Perform duty without aspiring for material gains and leave the result to God Almighty. During your academic studies, you would have encountered the law through the black letters of your books and case materials. However, when you enter the legal profession, you realize that law throbs with human interest, for law's concern is of the people. Laws breathe life in our minds and expect us to behave in a civilized manner with respect to everyone, be it humans or animals. Law is a communal enterprise based on order and procedure. It binds us together in mutual interest, mutual welfare, and mutual happiness. However, laws can only do so much until all of us are willing to participate in its endeavor. A law is not an antidote to prevalent social mores, rather it is a means to forge a new future based on the ideals enshrined in our constitution. Law in itself cannot solve the human problems. Law is merely a set of facilitative tools to render justice. The general notion that is often ascribed to my role as a judge of the High Court is that I deliver justice. However, as students of law, all of you are also capable of rendering justice in your own small but significant way. It is incumbent upon you to endeavor to lead the law a little better than you found it to be. The theoretical underpinning of my suggestion is grounded in the fundamental idea of justice, which is essentially the constant and perpetual purpose of rendering each person their due in light of the social circumstances. We live in a sort of society governed by rule of law. Rule of law, if understood and implemented properly, is a defense against oppressive structures such as patriarchy, casteism, and ableism. It is an aspirational goal which is beyond you and me as individuals, but towards which all of us have our parts to play. However, we must understand that rule of law does not depend merely on the constitution or legislations. It depends upon the political culture and habits of citizens, especially young legal professionals like you. In all of you are the guardians of our constitutional and democratic traditions. You must strive to make the legal profession more inclusive and accessible when you become a part of it. This is one way to further the goals of justice. If you are working in a corporate law firm, you must strive for a milieu that reasonably accommodates every individual, irrespective of the individual differences. If you are a practicing lawyer, you have a professional responsibility to work for expanding access to justice beyond those who have financial or social advantages. If you aspire to join the judiciary, it is necessary that you place substantial justice as the foremost goal of adjudication. As a policy maker, you can devise policies to socially and politically empower the marginalized. As you make your way through this profession, don't shy away from trusting your judgment, even when the path ahead seems unclear. Tough decisions may lead to unexpected outcomes, but they are ours to own. Today, I urge you to leave the path of predetermined outcomes and give life a chance. The beauty of life is in its excitement and sometimes uncertainty. Trust your instinct and work towards what makes you happy. As the famous author Ralph Waldo Emerson once said, and I quote, "Trust thyself, every heart vibrates to that." Iron string, nothing is at last sacred but the integrity of your own mind. Justice Sonia Sotomayor of the United States Supreme Court once said, and I quote, "I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a man who hasn't lived that life." Your unique perspective shaped by your individual experiences are invaluable. Don't be afraid to bring them to the table, even when they differ from the mainstream view. As you move towards your careers, way ahead, strive to be not just great minds, but also compassionate human beings. As James Joyce, famous Irish novelist and poet, said, and I quote, "To learn one must be humble, but life is the great teacher. Humility achieved through failures and experiences teaches us to preserve and grow." You all are not just law students, you're future decision makers, change makers, and future shapers. The world awaits your brilliance. Make it count, make it matter, and most importantly, make it yours. The law awaits you, and society needs you, not just as lawyers, but as ethical, empathetic, and dedicated defenders of justice. I conclude by saying there is no shortcut for success. There is no substitute for hard work. Believe in yourself. Focus on work. Do your prayers daily. And then rest is taken care by God Almighty. I wish all the best for all the children sitting here. Thank you one and all for giving me this blessed opportunity.
Thank you so much, ma'am. Thank you so much.
We thank Honorable Justice Ma'am for enlightening us with her kind words. We are deeply grateful, ma'am, for throwing light on the importance of hard work, dedication, and perseverance, and also throwing light on the important aspect that there is no shortcut to success. Today's generation is always seeking for that shortcut, that click of a button, which might give success in all fields. And we are grateful to you, ma'am, for throwing so much light on how it is important to climb all the rungs of the ladder to reach to the top. Now, I would like to read the profile of our Honorable Justice Abraham Matthew, sir, before inviting him to the dais. Honorable Justice K. Abraham Matthew, sir, is a former judge of the Kerala High Court. Sir hails from Kottayam district and has obtained his law degree from Law College, Thane, University of Bombay. Sir joined the judicial service in 1988. Initially, Sir joined as a Munsif magistrate, was soon promoted to the post of a sub-judge and a district judge subsequently. Sir was appointed as the additional director in the Directorate of Training before the High Court of Kerala in 2004. Sir served as the director in Kerala Judicial Academy, Ernakulam from 2010 to 2012. Sir was then posted as a Registrar Vigilance at the High Court of Kerala in 2012.
Yes.
And thereafter, Sir went on to serve as a District and Sessions Judge, Todupuzha, from March to December 2013. Thereafter, Sir was sworn in as the Additional Judge of the High Court of Kerala on 1st January 2014 and was appointed as a permanent judge with effect from 10th March 2016. After a glorious career as a judge, Sir retired on 18th January 2019. During the inaugural address, Honorable Justice Pius Kuriakose, Sir, had enlightened all of us that Honorable Justice K. Abraham Matthews, sir, is well renowned before the Kerala Judicial Academy as the best lecturer for all the students. With this background, I would like to call sir to throw some light and enlighten and encourage the law students here.
Thank you very much. It is only customary to give such comments or observations. Still, I thank you. Honorable Sister Justice Suryappalli Nanda, Thomas George and Associates, dear participants, only a few words. It has been a well-organized moot court. It was a moot court and not mute court. Very good. The performance of each and every participant was excellent. So equally good. And what is the object of a moot court competition actually? It's actually, it will help you sharpen your and promote your skill in arguing cases in a courtroom. But apart from that, it will give you an occasion to experience the thrill in practicing law. I think only a minority of these students now come to these courts. They prefer MNCs, corporate areas. So this will certainly help you prefer courtrooms, courtroom practice. So we were dealing with some constitutional problems. So basically, what is the question in this type of cases? The basic question is, what is justice? Justice actually means to give someone what he is entitled to, at the time at which he is entitled to it, and in the manner in which he is entitled to it. So that means a speedy justice, guaranteed by Article 21 of the Constitution. At the same time, speedy justice is not instant justice. In instant justice, there will be arbitrariness. But in speedy justice, it will be always, there will be fairness. Fairness not only in substantive laws, but in procedural laws also, as clarified by the Supreme Court in several cases. So our law is always dynamic. Who makes it dynamic? The law is made dynamic by advocates, not by judges. It is the interpretations given by the advocates that help these laws to become dynamic. Unless you give new interpretations to it, it does not become a dynamic one. How can you distinguish? How can you make it dynamic one? Or new interpretations, how can you make? See, the difficulty with the present generation is that they have become slaves of this software. See, software, you shall not be, it should not be a master of these junior advocates. It will certainly help you to search. Solely a search engine. You must read the entire text of judgments. And unless you are able to differentiate two cases on facts, there will be no interpretation. So always remember that. You should not become a slave of this software. That should be only help you to search, nothing more. Interpretations, new interpretations come from your competence to give interpretation. For that, experience is necessary. So come to courtroom, experience the thrill in practicing law. I have already told you that the performance of each and everyone was excellent, excellent. So I congratulate you, not only the losers, but the winners also, and the losers both the performance was exemplary. So thank you very much. All the best, each and everyone. Thank you for giving me this opportunity also to the organizers.
Thank you so much, sir, for your kind words. And thank you, sir, for enlightening us as to how it is important to choose and strive for litigation over corporate law, which is the essential interest that drives the youngsters today. And thank you also, sir, for enlightening us as to how it is important not to be a slave to technology, but to be the controller of technology. With these kind words, sir, we thank you for these kind words that you have enlightened us with. I would like to call upon our founding member, Advocate Thomas George, sir, to address the gathering with a short address. Sir is the founding member of Thomas George and Associates, formed in 1998, and sir has brought the firm to its stature today.
So without interruption, Anur, may I leave?
Yes, sir. Yes, I understand that the time.
Justice, thank you very much. Very nice meeting you though it is online. So thank you very much.
I equally feel the same, sir. Thank you, sir.
Thank you, Mr. Thomas George.
Thank you so much, sir. Thank you so much for encouraging us.
Thank you.
Thank you, sir, again for joining.
Today is Sunday.
Yes, I understand. I understand, sir.
Thank you very much.
Thank you, sir.
I would like to call upon Advocate Thomas George, sir. And before I call upon sir, I would just like to read a short bio of sir. Sir has been the instrumental founder of the firm, started in 1998. The firm has started in 98 in a one-room office, I must say. I am not only a junior to Advocate Thomas George, I am also his son. And I have seen my father and my mentor struggle over these years from 1998. An office which started with one room expanded to a two-room office and today occupies the entire ground floor of a premises. Over this passage of years, the firm has seen growth in the number of matters that it has taken, only with the ardent efforts and sincerity of Advocate Thomas George, sir. All the interns, sir has guided them and molded them as his own children. And many of the participants there in today's moot court competition are none other than the former interns who interned at the firm, and they will be a testimony to what I speak about Thomas, sir. Thomas, sir, with these kind words, I would like you to kindly address the gathering.
Thank you, Manu, for your good words to your senior or your father in both ways. I thank you for that. I'm indeed very deeply indebted to Suryapalle Nandagaru Justice because you have been always instrumental in encouraging us. Whenever Manu think about the moot, first word comes into his mind is your lordship's name. That he is so confident that you are there to support the younger generation. So with that, I am very grateful to you, madam, for all the help that you're supporting for this moot court competition. I have got some words for my younger generation who are here. I'm just reading out a quote from Christopher Reeve. So many of our dreams at first seem impossible. Then they seem improbable. And then when we summon the will, they soon become inevitable. And I want to tell you all, work hard and most importantly, have fun and make a history. This is my message to my participants here. I want also to tell you, there is no winners. All of you are winners because either you win or you experience. Your experience is giving you valuable guidance for your future. So take it in that spirit. I wish you all the best and I thank you for giving this opportunity. Mano, this is the brainchild of Mano. I should proudly say he has been instrumental in working on this and he is constantly, when I say, okay, this year we can postpone it to next year, he is very adamant that it has to happen because we had some hurdles this time. So we were having paucity of time, but still Mano was very particular. It has to happen. So I hope annually we'll be able to come out with better subjects for mooting. I thank you all very much and wish you all the best for participating in this and gain this rich experience. Let your future be enlightened and brightened. I wish you all the best. God bless you all.
We thank you, sir, for enlightening us with those kind words. Thank you, sir, for clarifying and telling us that in any competition, there are no winners and losers, but there are only winners and learners. Thank you, sir. I hope the participants will take this at the time of announcement of the results. Now, before I invite Honorable Justice Ma'am to declare the results, I would like to call upon P.C. Nirmala Ma'am for addressing the vote of thanks. Before I call upon Ma'am, a brief profile of Ma'am, if I may say. Ma'am has started her career in teaching. She was a lecturer in zoology at St. Francis College for Women in Hyderabad, with an illustrious career in teaching. After 35 years, holding various positions as the head of the department, the academic dean, the controller of examinations, she retired. And at the age of retirement, where people take to rest, she decided to study law, studied law for 3 years, and now is a practicing lawyer before the Honorable High Court of Telangana and all the tribunals and courts within the state. As Honorable Justice Matthew sir was casually commenting that ma'am was able to get judgments in such a short span, a small brief of that judgment, if I may say. Everyone in today's era is aware that it is very difficult to win a matter for insurance companies before the consumer fora in this country, because judgments are always in favor of the customers, the consumers, and not the insurance companies. People well versed with consumer law would like to agree with me on this. So, in the similar manner, I fought for the insurance companies before the district forum and lost. It was my mom, my senior. I would tell her my senior because she's senior in age, though she's my junior in profession. I'm very happy. She teaches me many unique things, even in law. The tables are not turned. I would say the tables are still the same, where I'm still learning from my parents. The unique aspect of this consumer law that I would like to refer is this case of consumer law was handled in appeal before the Honorable State Commission by my senior. And at the time of briefing her, I told her, see, this is the first case I understand. Please don't take it to heart if you lose. There are high chances of losing. So please be cautious of that and don't get emotionally hurt. So with that background, she went, she prepared, she argued. And months later, we saw that the judgment came in favor of her, in favor of the insurance company. And she was taken by surprise. So with that, we can understand as to that age is no bar, and litigation welcomes everyone from different fora, whether you have a background in law or you do not have a background in law, whether your father is a lawyer or a judge. Justice Nanda ma'am also here can be a proud testimony as to anyone, even without a background, can have a profession in law with sure hard work. With this background, I'd like to invite Nirmala ma'am for the vote of thanks.
Thank you, Manav. On behalf of Thomas George and Associates, I wish to thank all who helped us to conduct the 5th virtual moot court competition on 14th and 15th of December 2024. At the onset, I wish to thank our chief guest, retired Justice Pius C. Kuriakos, for having inaugurated our 5th virtual moot court competition. I wish to thank Justice Surapalli Nanda Madam and retired Justice K. Abraham Matthew for having accepted our invite to judge the final round of our 5th virtual moot court competition, and also gracing the valedictory function and announcing the results. Thank you, ma'am, and thank you, sir. I wish to thank senior advocates, Advocate Deepak Bhattacharjee, Advocate L. Ravichandar, Advocate Dr. Venkat Reddy Dontireddy, and Advocate Thomas George for adjudicating the semi-final rounds of the 5th virtual moot court competition. I wish to thank Advocate Surapalli Prashant, Advocate Manav Jessel Thomas, Advocate Rishabh Garg, Advocate Mrudulika Concepta, Advocate Daniel George, and myself for judging the quarterfinal rounds of the 5th virtual moot court competition. I wish to thank all the judges of prelims, Advocates Manav Jessel Thomas, Ruben, Manish Sharma, Somali Acharya, Ritik Shekhar Srivastava, Haider Tapia, Alladi Avinash, Nanusha, Shresht, Shubhra Singh, Yogita Jamula, and Naganathan Iyer. It was interesting this time that we had the researchers round bombarded with plethora of questions on the topic of 5th virtual moot court competition, the bulldozer justice, and seen an active participation from all the researchers of all the 23 teams, that the host Thomas George and Associates found it very tough to come to a free and fair conclusion. We had this time 19 colleges from all over the country participating in the present 5th virtual moot court competition, and we had 23 teams taking part in the competition. I thank all these law college managements and faculty for having sent their students to participate with vigor and enthusiasm in our 5th virtual moot court competition. I congratulate all the participants for your willingness and readiness in going through the various levels of 5th virtual moot court competition, even though we all know that only one team would be the winner. I thank all our coordinators, Tanita and Trisha, our court masters, and all others of all other court masters of all other rounds of moot court competition, and our volunteers in this moot court competition. I also thank our juniors, Advocate Shubhra Singh, Anuya and Harish, who are us great support in our office. I thank you one and all. Congratulations and all the best to one of you, each one of you. Thank you, Madam, Nanda Madam, once again.
We would like to pause for a minute before we declare the results.
Who will win?
Respondent.
Welcome back to all of you. And I know this is the most tensed moment for all the participants of this competition. We thank all of you once again. And we would like to specially thank Honorable Justice R. Basant sir for being the instrumental guide and helping us with his blessings and guidance every year for all of our competitions. Sir was the former High Court Justice of the state of Kerala and now is a designated senior counsel and practicing before the Supreme Court, handling various diverse important criminal matters. Without any further ado, ma'am, I would request you to kindly declare the results.
Best team TC24, Christ University, Bangalore. Manvi Nishit Chowdhury, Simran Agarwal, and Vaibhav Raj constitute the TC24 team. Runners up TC10, Christ University, Bangalore. The members in TC10, Vijay Lakshmi Reddy, Griffard HM, Rohul S. Gowda.
Sorry.
Best speaker TC06, Speaker 1, Shreya Ishan. Best researcher TC14, Government Law College, Trivandrum, Malvika R. And best memorial TC24, Christ Union, Bangalore. Christ University, Bangalore.
Thank you, ma'am, for declaring the results. Now, before we part, please.
Please announce the prizes.
Yes, sir. I'm doing that, sir. So for the best team, all the students will be getting a certificate of participation. All the students who have won any award will be given a certificate of merit. All the students will be given law books sponsored. The winners will be sponsored books by Gogia Law Agency. And as everything, an incentive is required. For best team, the cash prize is 20,000. For runners up, the cash prize is 10,000. For best memorial, the cash prize is 5,000. For best speaker, the cash prize is 5,000. And for best researcher, the cash prize is 5,000. I forgot to mention, in addition to certificates of merit, we are also giving trophies by way of courier. We shall send it to all your addresses to all the winners. We congratulate the winners and we congratulate the learners of this edition of the Moot Court competition. Before we part ways and close today's valedictory ceremony, I request all the winners to kindly raise your hands when I say your award so that we can click a screenshot and post it on our website. I request all of you to kindly raise your hands for best.
Raise your hand. Come in the meeting. 1 second, sir. 1 second. I'm so sorry. They're so happy.
I understand. All of you are happy, I understand. Kindly just raise your hands and we shall just pin you all and take. Okay. Pin.
TC10 also has to raise your hand, isn't it?
We are adding now only for best team. So best team, kindly raise your hands.
Raise your hands, guys. Raise your hand.
He is a leader. The researcher is a leader.
Yes, this is TC24. Do we have all from TC24?
Yes, sir.
Okay.
Physically raise your hands, not with your.
Physically raise your hands, guys.
Yeah. Not that. You remove that hands up. Yeah.
Yes, yes. Okay. Now you can lower your hands and all of you all please smile, say cheese. In the previous rounds, I made a comment on TC24 researcher that he has a ever smiling face and the smile is seen by winning this round. Next, I would like to request runners up to kindly raise your hands so that we can. Runners up. Yes, do we have all the runners up? Yes, I request all of you all to kindly smile, say cheese. You can lower your hand now, sir. Yes, say cheese. Now I request the winner of the best memorial to kindly raise your hands.
Please announce the name. Okay, okay.
Best memorial, kindly raise your hand. Oh, it's again TC24. Okay.
Sir.
Great.
We have one more. Yes, best memorial. Okay. So we'll have this again. Say cheese again. We thank you, ma'am, for waiting to take pictures as well. Next, I request the best speaker in prelims to raise his or her hand. Best speaker in prelims is there? No, the best.
Can you announce the name?
Please announce the name, no?
Yes, sir.
Best speaker TC 0661 Shreya Jha Ishan.
Shreya Jha Ishan. Is she there? I don't think she's there. Next, I would request the best researcher, Malvika. GLC Trivandrum, is she there? Malvika, is she there?
Yeah.
Yeah, TC14.
Yes. Yes, kindly say cheese.
Raise your hand.
No, now it's fine, sir. Smile, yes. Now I request all my volunteers to raise their hand so that my volunteers and my team, my juniors, all of you all, please raise your hands.
Court masters, your video's on.
Come here, come here. Come here. Pull your chair here. Sit here.
Court masters. Other court masters of previous rounds are here. You also can raise your hands. My juniors, please switch on your cameras.
Yeah, Shubhra is there.
Yes.
This
So,
is-
any other
Anu, you show your
volunteer is
face
here?
completely.
Please switch on your camera. Yes. Okay, all say cheese. With that, we would like to close our moot court competition for 2024. We once again thank you, ma'am, for joining this edition, for giving us your precious time on a Sunday, despite having a heavy schedule, not only Monday to Friday, even yesterday was a National Lok Adalat. Thank you, ma'am, for giving us your valuable time. We also thank Abraham Matthew, sir, who has left because today is Sunday, sir, had to leave to church, for his valuable time as well. He gave us in today's day.
We are indebted to you, Your Lordship, for giving your valuable time.
Thank you, madam.
Thank